Hello, everyone. Welcome to the Heterodox Academy's virtual webinar on legislating intellectual diversity, a discussion of Indiana Senate Enrolled Act 202 and what it means for higher education. I am Alex Arnold. I'm the Director of Research at Heterodox Academy, where I also oversee the Siegel Center for Academic Pluralism. Joining me today is our intrepid Director of Policy, Joe Cohn. Joe, you want to say a few words about yourself?
Yes, well, thank you for having me, Alex. I've never been described as intrepid before, so that's a new one for me. So I'm Joe Cohn. I am Heterodox Academy's policy director. I've been working in the space of civil liberties and higher education for a little over a decade, and I'm really excited to be part of this conversation. I'm a lawyer by trade. I've done a lot of work on First Amendment work in particular in higher education and academic freedom issues as well, which are front and center considerations in this bill.
Great. So, as always, we always want to remind people who are participating in this webinar of the importance of adhering to the HXA way. So, we want to remind everyone in the question and answer period, especially, to model the five planks of the HXA way. So, make your case with evidence, be intellectually charitable, be intellectually humble, be constructive, not destructive, and of course, be yourself. That is, bring your convictions, your beliefs, and your doubts to the table. That's always good. Um, so this is going to be a virtual webinar, but we always want to encourage people who are watching to engage with Heterodox Academy in other ways. So there are three things you can do, at least three things you can do. One, you can subscribe to our newsletter, so you can see the QR code up there on the screen. You can also join and subscribe to our uh, Free the Inquiry Substack, which has got all sorts of hot, juicy content coming out on a weekly basis. And then finally, we're very grateful for all of you watching who are members of Heterodox Academy. Thank you so much for joining this movement for open inquiry in higher education. But if you're not a member and you really do care about open inquiry in higher education, we strongly encourage you to consider applying to join membership. It doesn't cost you anything, and we would love to have you on board. So with that, I'm going to ask Joe a sort of big question to start off this webinar, and that is, this bill has a lot of different provisions in it. Some provisions are somewhat orthogonal to Heterodox Academy's mission, but a lot of provisions are actually quite squarely on scope, on target for Heterodox Academy's mission. So why don't you give us your rundown of the good, the bad, maybe the ugly when it comes to the provisions in this bill?
Yeah, thank you, Alex. So this bill was enacted in 2023, and that was before Heterodox Academy had a policy department. So moving forward, when bills are in our wheelhouse, we're hoping to engage on them and uh, talk with lawmakers about what we like and what we don't like to hopefully shape laws to uh, first and foremost, we want them to be constitutional, and then afterwards, we want them to set, good policy. We didn't get an opportunity to do that this go round, so I was particularly, curious to run the analysis and see, what it is that we would think about the bill because it's one that tackles so many issues that are important to Heterodox Academy values, in particular, open inquiry and viewpoint diversity. So, um, when I look at a bill that on its face seeks to tackle those issues, I get really excited about the possibilities and always a little bit anxious about what it might, be misplaced on. So this bill didn't disappoint because it had a healthy mix of things that fall into both categories. On the pro side, it had a provision that dealt with diversity offices at institutions of higher education in Indiana, where it said part of their missions should include promoting cultural and intellectual diversity. It wasn't a ban on other forms of diversity at all. Instead, it just said, make sure this is part of what you're promoting. So I view that as a positive and healthy approach to thinking through the issues rather than zeroing in on the tensions between different forms of diversity. Uh, Another thing that I put in the pro column is that it required schools to adopt policies on substantial disruptions of other people's protected uh, expression. Um, I would have liked that provision to be drafted a little bit more carefully than it was, but by and large, because it isn't the actual text of the policies themselves, and it's just directing uh, institutions to create a policy of their own. It didn't itself pose a problem through being, not exactly precise of what I would want in such a policy. For example, on disruptions, I would want it to require the disruption to be knowing, uh, as opposed to, construction taking place, on the campus, and that somehow, having an impact on someone's protected expression. So there are a lot of different ways that I would tighten up an institutional policy, but didn't see a problem in how the language of the bill itself was written. A major part of the bill, however, uh, deals with reforming tenure and post-tenure review. And that's where the bill starts getting into both things that are in the pro side and in the con side. Um, on the pro side, with respect to evaluating both tenure and post-tenure review, it says that institutions can't factor in to the analysis whether a professor has expressed dissent or public commentary on issues, or whether they criticized school leadership, or any of their extramural political activity. So I think that those are valuable uh, protections, especially for extramural speech and research that fall right in the realm of academic freedom that we hope to see and hope to advance and promote. And again, that applies to both the tenure review process, promotion process of all kinds, and also post tenure review. Um, I'll talk about the negatives at great length, as well, of course, but just to check up a few boxes still while we're in the pro column, it has a helpful provision requiring the institutions to adopt institutional neutrality policies. And uh, Heterodox Academy has been working hard to convince institutions to do that. So we're pleased to see that in the legislation. And then it also has a provision about not requiring students applying for admission or faculty at hiring or promotion periods to pledge allegiance to particular political or ideological movements. So, and then it has some helpful carve outs allowing institutions, of course, to consider the quality of someone's actual work in the field that they are applying for a position to teach, for example, um, or subject to promotion within the department. So those are all provisions that we put in the positive side. On the negative side, and Alex, feel free to jump on in since I know I'm taking a little while here since there's a lot in the bill. The reforms to the tenure and post-tenure review process include provisions that, in my view, are on some shaky constitutional ground. So it the bill instructs the Board of Trustees to adopt a policy that says that promotion and tenure in particular cannot be awarded to a faculty member if the Board of Trustees determine that that person is unlikely to foster a culture of free inquiry, free expression, and intellectual diversity within the institution, likely to expose students works from a variety of political or to the faculty member's academic discipline. Or three, likely while performing teaching duties within the scope of faculty members' employment to subject students to political or ideological views and opinions that are unrelated to the faculty member's academic discipline and assigned course of instruction. And of course, that same criteria is used to evaluate, again, post-tenure review. And that poses a few constitutional problems that we're going to discuss more in depth, but they fall under two broad categories: general academic freedom concerns and also some vagueness concerns that would be a more traditional First Amendment, vagueness and due process vagueness challenges.
Great, Joe. So we've got, oh, Joe, there, great, Joe. So we've got one question that we might as well take the time to answer here, and that concerns how the bill defines one of its core concepts. That is, how does it define cultural and intellectual diversity?
So I think that that's one of the weaknesses of the legislation is that there isn't really a sufficient, definition of those terms. And, more so than needing the definitions of those terms, when it talks about providing people, uh, exposure to different scholarly works, well, how much, is sufficient? How many ideas need to be presented? And there's a tension here. Obviously, at Heterodox Academy, I hope it's obvious. We want professors to, be able to share the viewpoints from across the political spectrum that they hold. Um, we want them to not have any government infringement on their ability to explore uh, challenging topics and those that might be disfavored. Um, but we also believe in faculty members, rights to have their academic freedom to determine, what it is and how it is they're going to teach a lot of these topics. So there's a little bit of a question about how prescriptive the government should be in terms of requiring, this degree uh, or the specificity or lack of specificity of diversity of materials, especially when it's tied to the consequence of will you get a promotion or will you not get a promotion? Because, diversity can come in the forms of in a particular class, but it could also come from a pluralism of multiple classes being offered. And I always ask, is it really a problem for a professor to? I don't think so, especially not curriculum.
Yeah. So, I mean, just for reference, the bill defines intellectual diversity, does not define cultural diversity. It does define intellectual diversity, but not in a very helpful way, in my opinion. It's intellectual diversity means multiple, divergent, and varied scholarly perspectives on an extensive range of public policy issues,
Yeah,
which I'll just say as a philosopher, uh, intellect, that's a very narrow definition of intellectual diversity because you can disagree on scholarly matters about a wide variety of things besides public policy issues. So one complaint is that this is just too narrow, but I think, Joe, your view is this is also just kind of vague, right?
right. And, vagueness is especially a concern, uh, when a statute is making particular requirements, because under the First Amendment, a statute is void for vagueness if person of ordinary intelligence can't figure out what they're required to do and what they're prohibited from doing. That's, essentially, black letter case law, um, you know, uh, in vagueness doctrine from Granted versus City of Rockford is like one of the key, cases that can set that standard. And not only do you need people of ordinary intelligence to be able to understand, the what's allowed and what's not allowed, but the law has to provide enough standards for, judges to evaluate that after the fact if there's litigation, so that there isn't an arbitrary, application of requirements. And of course, you know, third is that, from a free speech perspective, you want to make sure that uh, bills don't chill people from going into certain areas. And of course, in a class setting, there's only so much time to do the teaching. So if, if you're requiring a certain amount of extra stuff, it's going to push other materials out.
Yeah. So I have a question here, which is kind of a very big picture question. I mean, so maybe I'll pose it. I'll pose it this way. This bill represents a sort of top-down way of addressing the problem of, among other things, the problem of viewpoint diversity. So it's got provisions in it that aim to have people as they're hired and promoted in the faculty evaluated along the lines of like how competent are they, how good are they at fostering an environment or a culture of intellectual diversity, which is I think we've been talking, it's sort of vague what exactly that means, and that's concerning for a variety of reasons. So, do we at HXA have we developed a kind of uh, real clear idea of what we think intellectual and cultural diversity might mean, and do we have maybe model legislation that we think other states or Indiana might adopt to address issues of viewpoint diversity? And if we don't, like, what are some of the challenges that such legislation might face?
Yeah, that's a good question. We're still working on those questions because a lot of factors go into play to thinking conceptually about what it is about viewpoint diversity or lack of viewpoint diversity that really impacts the quality of higher education and the health of uh, higher education, and then translating that into legislative language that has enough clarity to avoid vagueness problems, to be more productive than counterproductive is a real challenging process that we're just getting started on. The policy department just launched in August, and we're really working through those questions very, very diligently.
Yeah, so this is an issue that we're thinking about, and whether legislation is the right tool to address problems of viewpoint diversity is, I think, a live question that we're considering. And the answer could be yes, in which case we've got to surmount this challenge of developing legislative language that does the job while remaining constitutional and, frankly, while also remaining true to HXA's principles. And we're at the very beginning of that process. Um, so we have a question here. To what extent does the legislation hold administrators accountable for what happens? I'm not sure what happens on campus or what happens in classrooms, and not just professors. So this question pertains to their responsibility for what happens in the classroom, as well as actions and statements they're making outside of the classroom.
It doesn't really have an effective, tool to do that. It's directed at institutions and ordering them to adopt, policies. Um, and, you know, schools are always in a position when you're a public institution of understanding they're also returning to those same lawmakers for their funding annually in the budget. So, or biannually in some legislatures. From that perspective, it's always, administrator beware if you're going to just flat out ignore a legislative edict. And that, of course, puts institutions in a lot of rocky positions if legislation isn't constitutional, because until it's struck down, you still have a statute that you're obligated to try to implement as best you can with whatever constitutional limitations are in place.
So we've got a question here now about kind of how HXA's. It's about a lot of things, but it's about how HXA's position relates to the ACLU lawsuit that was just recently filed on behalf of some professors at Indiana University. So how our position compares to some of the complaints raised in the ACLU lawsuit. And this questioner also asks whether or not, before HXA had taken a position on the quality of the this bill that we're discussing, whether it would have made sense for us to wait until there was some legal defense offered of the bill in court, and also whether we would have waited to see whether the state of Indiana offered some narrowing constructions of some of the terms of the legislation. So that sounds like a lawyerly question. I'll let you handle that, Joe.
Yeah, no, I appreciate it. Well, let me say a couple things. First of all, um, we did our first run analysis before seeing the litigation. Um, and so it was before the benefit of the ACLU complaint. And we ended up, as you see in what we said in our pros and cons, the litigation, of course, because litigation doesn't tend to work this way, doesn't list what it likes about the bill. It challenges a couple things. And the questioner is right that we ended up agreeing with them on two primary issues, the vagueness aspects of it, um, and some of the academic freedom issues in terms of compelling and shaping what individual courses uh, might have to look like. Um, in terms of whether or not there was a any narrowing from the state. This is actually the second lawsuit filed against the bill. The first one was tossed without prejudice, I believe, instructing the plaintiffs to wait until schools actually adopted the policies they were ordered to do in case they had done that, in case they had helpfully narrowed some of these terms. Um, and in the article that I wrote about the bill, I linked to uh, the statutes that are created in some of the policies, and they didn't really take that opportunity to narrow things in any helpful way that solved the vagueness issues. So I don't know that I really have to wait until I hear what the government says to get an understanding of these questions, because the vagueness comes in from not knowing how much diversity is required, whether extramural, speech is gonna, and content uh, is considered in terms of the likely exposure to students, et cetera. Those problems are just there on the face of the bills and the policies as far as I see them. Um, I don't think it's impossible for the legislature to revisit the bill and tweak things in it in ways that might be helpful, but we're operating under the text as it is.
Yeah. So this is kind of a related question. Does the bill empower the executive, I assume that means the governor, to fill in the vagueness in the statute? Can the governor, for example, cut funding to a university for not following the governor's view of what the law means?
No, I don't see that in this bill as a provision. And if on a reread I see something that would allow the withholding of funds, I'll certainly, you know, say something about that, uh, publicly, either on social media or elsewhere to clarify. But I don't recall seeing anything like that in the bill.
Yeah. So this is kind of derives from a question we just got. I'm going to phrase it slightly differently. But the way this legislation is written, who actually has a lot of discretion in making decisions about whether particular faculty are in compliance or conform to the provisions of this bill or not? Like where does the power kind of accrue as a result of this legislation?
The power largely rests with the boards of trustees, um, who are asked to make these determinations. Um, and, there's at least some concern in terms of whether or not boards of trustees really have the expertise to evaluate whether professors in all sorts of fields, some they might have the expertise, individual trustees, and some they might have no idea whatsoever in terms of which, views really should be incorporated uh, from the pedagogical perspective of what would be helpful or unhelpful, um, and knowing kind of which ideas would be too far afield for the for the course. Um, and I want to point out for a moment, this is different than a ban on an idea from being included. Um, we don't support bans of what can be taught in classrooms, um, but it poses in a different problem in terms of just the lack of clarity.
I see. So let's take another question here. So questioner states the HXA position appears to me to downplay the current lack of ideological diversity in Indiana institutions of higher education. Even assuming that our concerns, HXA's concerns, are valid, isn't striking down the bill as unconstitutional a bigger danger than having it upheld? Given how bad the situation is today, Indiana has tried to do something, and the outcome in Indiana will likely set the tenor for debates about ideological diversity in other states around the country. Shouldn't HXA be doing what it can to try and get a win in the battleground to promote ideological diversity rather than just a decision striking down the legislation? Is HXA arguing, for example, that the problematic provisions in the bill are severable from the bulk of the bill?
I don't know what the rule is under Indiana law in terms of whether or not they have to include a severability clause, just a clause saying, if there are multiple provisions and one of them is struck down, the whole thing goes, or the parts that are salvaged stay. So I don't know the answer under Indiana law. What I'll say is more general, which is unconstitutional solutions just aren't solutions, period. And we're never going to ever support anything that we believe is unconstitutional after we run our analysis. I don't mean to, and I certainly don't think HXA means to downplay concerns about the lack of intellectual diversity in Indiana or anywhere else. It's one of our core pillar values, but we do need to carefully think through solutions to the problem so that they're durable. um, Taking a short-lived win. And frankly, uh, even had HXA stayed silent on the issue, the litigation is ongoing, and the court's going to decide whether or not these arguments are persuasive or not. But I've looked at these questions for many years, and uh, I my instincts tell me, my analysis tells me that this is too vague to be workable as a framework. Um, and I'd like to, and we plan on spending the next several months thinking through things that might be a better way to address this very same problem, because I don't disagree that it's serious. And we're certainly not arguing for the status quo, but you got to start off on the right foot, and you got to always be on sound constitutional footing.
Yeah, and I think there's another point that we could make as well, that there's always a possibility that the provisions of this bill could be leveraged in order to worsen the problem of ideological diversity, right? By sort of creating a weapon that your enemy can use against you. I don't know if you want to comment a little bit more at length on that sort of idea, Joe, but that's one of my concerns about the bill, is that you forge a weapon that your enemy can use against you.
Yeah, I have said over the years, and people who know me well, and a lot of lawmakers have heard me say this over the years, don't fall in love with the club that will use to beat you over the head. And by that I mean, if we are concerned that some views are absent in higher education, and if we view administrations as having played an active role in making the case and disfavoring particular views, empowering those very same administrators to regulate, class content, or punish people, or withhold promotions and jobs, uh, could very well exacerbate that problem. That's clearly not the intent here. I mean, I think, that I do want to say one thing really, you know, unequivocally positive about uh, this bill, and that it was a very serious attempt to address the issue, and it wasn't an attempt that, when my reading of it comes from a particular partisan valence that just ignores, considerations on the other side. I mean, sometimes you see, legislators unable to divorce their own politics from a situation. But that's not the case here. If they made mistakes, they made mistakes on the margins, important ones, I believe, in terms of how would be implemented, but not ideologically driven ones. And that's really a good starting point. And what that tells me is that if the bill is struck down by this lawsuit, the legislature will be receptive to hearing ideas about what can be done instead to make this, to make this work and to prioritize improving open inquiry and viewpoint diversity. And I'm really glad that they recognize that those two things are essential for the health of higher education in the state. So we're playing with a situation where we have people acting in good faith, and that's a position I prefer to be in.
So we've got a question here. Questioner says this bill's mechanism is removing people from jobs for the way they think. No, yes or no? Or elaborate.
I mean, I think it could. I mean, certainly, I mean, I've now subsequently, from my first run analysis of the bill from the first time I took a look at it. I've read the complaint, and the plaintiffs talk about ways in which they would have to adjust their their courses, um, in ways that they weren't particularly comfortable in doing. So, there's always going to be tensions about whether or not you need the diversity of viewpoints. Again, we're talking about what's being taught. We're not talking about whether or not a professor is willing to accept counter arguments from students here. We're talking just about like what they choose to teach. Um, whether or not you need the diversity in, whether or not you just need that diversity of courses being offered so that no view is cut from the academy.
Right. So we have again this question about, would HXA consider developing a model legislative bill that would encourage or even require intellectual diversity without infringing on academic freedom or constitutional rights? I mean, I think that would be nice if we could do that, but I think Joe, well, you could say whether or not that's something you'd like to do, and then maybe you can talk about some of the prospects, but also the perils of that exercise.
Well, I plan on dedicating a considerable amount of effort to thinking through what can be done to promote intellectual diversity and open inquiry in legislatures. Um, I don't know that it will take the form of mandates versus other, kind of innovative, tools to reward and promote those values. I don't know yet. I'm skeptical that the mandate direction, because I haven't yet figured out a way around the vagueness issues presented in this bill. Um, but I don't want to rule out the possibility that those problems can be solved. There have been a lot of issues over the years that I started out skeptical on, and someone's contribution to the conversation midway through, a light bulb goes off, or they figure it out, or someone on the team figures it out, or I figure it out. So I don't want to rule it out in its entirety, but this is going to be a long haul process of trying to get things right for the long run.
So we have a question here. To some degree, intellectual diversity must be vague. Many things in philosophy are aversive to definition, but at least can be characterized. I'm sympathetic to that, being a philosopher myself. So science, pornography are some examples. So does this mean that the bill in question, or the bill we're discussing, is designed more readily to go after more obvious offenders? So some examples. If a faculty member is constantly speaking on racial diversity and yet is teaching a math class or is a math professor, or perhaps someone is proselytizing much of the class instead of teaching physics 101, or numerous students complain that a professor sends a chilling pressure to self-censor, self-silence. So like, is this bill really tailored to go after just the really bad apples or something like that. And then I think this is also a nice opportunity, Joe, for us to talk a little bit about some of the provisions in this bill about
Right.
complaint, right? So the bill does contain, I think it's Article 39.5, Chapter 2, Section 4. Uh,
Hmm.
it mandates that institutions have to establish complaint procedures for both students and employees to submit complaints that pertain to the provisions of this bill. Um, so yeah, I mean, you could the question narrowly construed is, is this bill really aimed at targeting obvious offenders? And then we can talk a little bit about these complaints procedures as well, and some of the, well, I think mostly downsides of them.
Yeah, I mean, I, there's already, procedures in place for students to do annual reviews and generally for complaints. So I'm not against there being that form of accountability. I don't think HXA would be against that form of accountability. This is specifically, however, about complaints about what someone chooses to include in the scope of their teaching, not whether or not, they engage in any form of illegal or unlawful activity. So I'm skeptical, of a complaint line for that, for that purpose. I'm always open to, boards of trustees knowing and understanding what's being taught so they can decide whether or not there are gaps that they also need to fill, whether it's like adding another section of someone who wants to teach something from another perspective, um, as one potential, kind of way to think it through. Um, the AAUP 1940 statement, Principle on Academic Freedom and Tenure, has really kind of helpful language that faculty members should be careful to avoid persistently introducing material which has no relation to the subject matter. And there's a provision in this bill that kind of tries to mimic that, but doesn't include the concept of persistence. It's, when you're doing the tenure, it's are they likely to ever introduce something that isn't germane? It's small things like that that make dramatic differences in people's rights. Because there is a free speech right and academic freedom right, without that persistence. And there's a long history in the Supreme Court of providing, for academic freedoms, starting with, Sweezy versus uh, New Hampshire in 1957, where the court, talks about how civilization will stagnate and die if we're not, protecting, academic freedom. And, then you have, Keyshian versus Board of Regents, a decade later that has, really important language on academic freedom as well, where it talks about, that the First Amendment doesn't accept any laws that would cast a pall of orthodoxy, over the classroom. And, so we need to be, careful when trying to evaluate, that concept. So we do have to be exploring tools to address what is a serious, problem, of course, because, we don't need to be, convinced. I think HXA, its founding principles, uh, acknowledge, how essential viewpoint diversity is, and I don't think that we would exist if we thought that balance had been struck, by and large now. So, um, so we're absolutely on board with trying to improve in these areas, but the solutions, need to be mindful of the, countervailing considerations.
So we've got another kind of picture, a bigger picture question here, sort of long. So I think we can safely assume that there is uh, a more liberal slant in many universities, including perhaps at Indiana University and Indiana universities. And maybe some of this is due to maybe discrimination in hiring, discriminating against people on the basis of their political or ideological convictions. And so, one part of this question, asks maybe the Indiana legislature should have greater freedom in addressing the problem, given that it's because of discrimination. And then the other part of the question is maybe a solution is to create alternative institutions within Indiana universities, something along the lines of what Florida has done. So, like the Hamilton Center at the University of Florida or the School of Civic Life at the University of North Carolina. What are your thoughts personally about that, Joe? Not speaking.
Yeah, I'm going to speak personally for it for a moment, just because HXA is still going through and evaluating and thinking through, what we think. We haven't reached any, firm like conclusions one way or another. Centers that deal with these issues, with academic freedom and free speech and civics in general, I think are positive developments, and and I think that I don't see any problem in those. Um, if a concern is that there's too much bias at institutions, or the entire institution is biased in one particular political direction, I think it's an interesting idea to create, public institutions that are biased as well in terms of a plurality, solution. Um, I certainly I'm more receptive to that idea when it's about providing resources to make sure that certain things are taught everywhere, whether it's at this institution or the other institution, et cetera. Like, okay, we did our research to know what's being taught. We see that there's a particular slant. Maybe, we provide funding to ensure that there's additional hiring to ensure counter points of views are brought to bear. I don't love the idea of institutions being siloed into totally biased directions at public institutions, and there's certainly a lot of private institutions to pick between if you want uh, to go to an institution that has those slants. So I am more intrigued personally by the ideas that try to create better uh, viewpoint diversity and intellectual inquiry here. And that's why, even though I'm critical of where this bill landed, I said earlier on that I am impressed with the overall attitude of the lawmakers in the bill, that wasn't about trying to fight fire with fire necessarily, with like, okay, you don't like how you're doing it, well, we're going to show you how we would, you know, do it. So, um, I don't know. I mean, nothing's off of the table.
Yeah. Um, yeah, we are definitely thinking about the proliferation of these centers, like the Hamilton Center, like I mentioned. There's ones at University of Texas, Arizona State University has got one as well. Um, whether those are models, perhaps, of encouraging greater viewpoint diversity within academia. But yeah, there might be some downsides as well in terms of creating intellectual ghettos and creating further bubbles that people don't get out of. So we've
Yeah,
got a question here about, well, I'll just quote the question. Could you speak to the issue of unqualified and often politically motivated trustees being the judges of whether or not a professor introduced material in their teaching that is unrelated to the subject? How would a trustee know what is and is not related to the course?
there are so many fields of study that I feel that I personally would be uh, unqualified to determine, what's the proper scope, which ideas, you know, you know, I would expect to see in a course, and which ones, I wouldn't expect to see. I think when an institution is operating at its healthiest, you have uh, departments with department chairs and other faculty members providing input, all, hopefully with the attitude that we're better off, with more viewpoints being heard. Of course, we know that that isn't always happening. Um, if it was always happening in that way, again, HXA uh, wouldn't uh, wouldn't exist. So I don't need to be naive about it, but I'm trying to think through the cultural things of how do we get us to a position where that's happening more often. And I'm not sure that just empowering trustees to figure out what's appropriate in anthropology and what's not appropriate in anthropology makes a tremendous amount of sense, specifically for the lack of expertise. In a lot of places, again, I just don't agree with injecting political bias too often as a way to fight what you see as political bias on the ground. Um, but uh, but I also don't want to paint with a broad, brush either. I think a lot of trustees try in good faith to kind of think through these issues, and we want to support them when that's what's happening.
Yeah. Um, so there, we've got a question here. I think that's a follow-up of our discussion of the complaints procedures. So I think it is, correct me if I'm wrong, anonymous attendee. So what constitutes evidence relevant to a complaint? Will this legislation lead to recording classroom activity, or is word of mouth sufficient?
You know, I don't think they're contemplating, necessarily courts of law at the beginning where people need to be under oath to show. So I think they're expecting it to primarily be word of mouth and then to ask other people and to do investigations. I don't know that that's really a great uh, framework, um, for this process. But I think that's what they have in mind. Now, of course, if it turns into litigation because a uh, promotion or a job is uh, withheld uh, on the basis of complaints that they weren't teaching diverse enough um, ideas under the bill, and the board of trustees said, well, we heard these complaints, etc. Um, then all of a sudden you're looking at discovery and trying to figure out what the factual records were of what they really based the decision on. It gets kind of complicated. Um, so one of the reasons why it's more complicated is I don't think we've ever seen anything exactly like this before, where it was formalized by a state law, setting concepts, out that are admittedly, or at least from my perspective, pretty broad and undefined.
Yeah. So we just have I guess it's an anecdote. If you want to comment on this, someone from Indiana University says that there's a faculty committee who looks at these complaints. And as of now, there's only been a single complaint which was dismissed. And then the bigger impact seems to be faculty members self-censoring, especially discussions about the election or even promoting voter registration in a nonpartisan way because they fear complaints. So that seems to be more grist for the mill in terms of like, this complaint procedure as outlined in this legislation might be leading to some chilling effects.
That's certainly the concern in the provision that talks about withholding positions and tenure from people who have, you know, introduced concepts that were remain again without the requirement. Um, I think better language on that exists out there. Not to toot my own horn, but I have written some that have been enacted into law. The laws in the state of Tennessee on this front, and also in North Dakota, um, you know, talk about protections for faculty in classroom speech, unless they are introducing topics that aren't germane and using up a substantial amount of instruction time to do so. Because eventually, students have the right, if they're paying tuition and they want to be taught, chemistry, to be taught chemistry and not to be, subject to uh, repeated, persistent monologues about someone's politics. So there is a line, but law has to carefully reflect what those lines actually are. It's not enough to be in the correct direction or vicinity. So that's an area where the bill could be improved, and it's not hopeless to do that. And of course, we're really concerned about the chilling effect that that a provision like this creates for faculty who are policing their own speech more so than they should. And that's not to say they shouldn't be policing their own speech at all. Again, they shouldn't be persistently injecting in irrelevant stuff.
Yeah. So, let's see here. One question we have here, it's more just sort of a comment, and I think there's some maybe interesting disagreement among people who are viewing this webinar about the extent to which there is a what the problem with academic freedom or what the concerns about academic freedom are and what the real problem is. So, one person notes that it isn't just that we need more viewpoint diversity, it's that we need to combat the de facto contempt for academic freedom that is already in place throughout higher education. If you have views that run counter to those of 95% of the current faculty and administrators in higher education, you will be filtered out in applying for graduate studies or on the job market or when coming up for tenure. And there's as a result, there just is no genuine academic freedom currently because of sort of ideological bias, right?
If
Um,
you can hear my cat in the background, I think he's agreeing with that. Um, but there's a helpful provision in the bill, and we listed it on the pro side, that talks about not uh, allowing any institution to require a pledge, in support of any political or ideological movement, as part of the hiring, and promotion, practice. Now, I mean, do I think that language could be written a little bit better? Yes. But do I think that one generally gets it right? Yes. Uh, it includes, helpful carve-outs for allowing to consider someone's actual writings and their uh, and in the subject they're being asked to teach. Um, so, I agree that that's a problem, and I think the provision in the bill that tries to deal with some of that problem. Oh, he'd like to participate in the seminar. Sorry that my apologies, everyone. Comet is now an active participant in the seminar. Um, uh, I think that's a helpful provision. And even if the entire bill gets struck down, you might see HXA back in the legislature, or, some version of that part of the bill to be reinstated. But I agree, there's a lot of work to be done on that front.
Yeah. So we have a question that's sort of generally about the concept of academic freedom here, which is whether academic freedom already includes the responsibility not to engage in monologues about one's politics. I mean, in the classical sources on this issue, I think of the 1915 AUP Declaration, that's the case. You quoted from the 1940 Declaration. Do we have any evidence that academics do not enforce this with one another? I mean, I guess my just anecdotal experience is that there are plenty of academics that do engage in monologues about politics and that they're not always not and oftentimes or sometimes in an irresponsible way, but they don't seem to suffer any kind of consequences as a result. But I don't know. I mean, I
Well,
think, yeah. What do you think, Joe, on this
well,
issue?
I'm a strong proponent of setting rules that provide people for protection when they're in the right. And I know that there are attempts to get faculty members fired for expressing political views, because there have been enough, you know, court cases and incidents that I've seen about that. And I think the 1940 statement sets the right line. So codifying and locking in place that line so there aren't abuses uh, will help regardless of how often that line is violated. And the truth of the matter is that that protects uh, the faculty member targeted for protected expression in class, you know. Um, and that's really the part that I'm actively concerned about. I'm not looking when I try to set, if I'm looking to set this line in legislation, I am not looking to uh try to go after, faculty for crossing it. But I understand that institutions do have the right to do so, and setting the line in the right place protects people on both sides of it. The students who are, even if it's rare, who are subjected to repeat, persistent uh, content that's not germane, and protects the faculty members who are being accused of that for, protected speech.
Yeah. So we've only got about 5 minutes left, Joe. And I think, we've got a couple other questions, but I think they would take us beyond the time we've got left. I was wondering if you wanted to just sort of comment on, um, just speculate, and we can just tag this as speculation, but where you see the future of these kinds of bills in the United States going.
I hope there is more legislation that tries to think through these really important, issues. Um, I'm not expecting them all to get it right out the gate. Um, they do that. That's ultimately how I view my HXA is to try to get the best policies on the ground and values, and also when outside government actors are involved to make sure they set lines that actually help in these areas versus hinder. And when I look at this bill, like I started up top, there are a number of things that I really, really liked about it. And there were some things that gave me pause. Um, and I'm one of those folks that not talking about making perfect the enemy of the good, but from a constitutional perspective, it has to not have any constitutional defects. That's not a question of perfect versus good. Unconstitutional bills are bad. Or let me be more specific, unconstitutional provisions are bad. Um, so when a bill has as a long list of provisions like we see here, we need to parse them out separately and not decide we're on team yes or team no across the board, but try to think through the consequences of it. And when we like what it's trying to do, but don't like its execution, then we need to put our thinking caps on ways that we can improve it. And maybe in some instances it will be minor tweaks to the way they're tackling it. In other instances, it will be a totally different strategy. Um, but uh, but we're thinking those things through because they're important, and we want, again, I think I've said it a few times in this presentation, I want solutions to be durable and helpful, and that's what we're aimed at. And I saw in the chat that someone was saying that they'd love to see proposed model legislation as we develop it. And before we close, I want to give everyone my email address, which is cohn@heterodoxacademy.org. And write to me if you want to be in the loop on those things, and I will do my absolute best to reach out to you, as we come up with things over the months and years. Because I definitely appreciate the feedback and the input. Uh, uh, you know, Constructive disagreement is welcome. And I see, Paul, you're at University of Utah, and I love it. And in Utah, I lived out there for a year in Salt Lake, and and
Great.
just turn it over to you, Alex.
Yeah, everyone, thanks for vigorous back and forth in the questions. It's clear we've got some disagreement, and that this is a topic that really animates people, and that's good, because it's an important topic and it's a tough issue to solve. So, if anyone wants to relive this webinar, I believe it'll be posted to Heterodox Academy's YouTube page, which you should go click like and subscribe and turn on notifications. That's what I always do on YouTube. And again, as Joe said, if you've got ideas, send them his way, cohn@heterodoxacademy.org. And thanks again, everyone, for your participation. It was a lot of fun. So, in the meantime, I wish you a good rest of your Wednesday, or if you're past the International Dateline Thursday, and have a good rest of the day. Bye bye, everyone.
Thank you. Have a wonderful one.